All right, ladies and gentlemen, we're just going to pick up where we left off before break. Prior to break, we had been working on the Constitution. We'd gotten through the articles. We talked about how Article 7 said of 9 of 13 states were needed in order to ratify. We talked about how New York was being difficult, Rhode Island was just not even showing up, and that there were concerns that New York had about things that were in or were left out of the Constitution. We then talked about a little bit about the Federalist Papers and how um, the original authors, not identified at the time, Hamilton, Madison, and Jay, put together a number of responses to the New York legislature's concern that there were things missing in the document, and they tried to convince the New York legislature that they didn't really need to be fearful because there were limitations of the federal government in the document. But again, even though they tried to assure those individuals that there were protections there, they weren't necessarily buying into that. So one of the authors of the Federalist Papers, James Madison, he puts down his thoughts on paper and he says, is this what you're concerned about? And the reality was that is a major concern. New York legislature was very concerned that there was nothing really listed in the document that was going to protect individuals from the abuses of the federal government. Keeping in mind, they had just broken away from the British, so there was a concern about what abuse could there be from a new national government. They were also very concerned about state rights. Even though there was a list of what Congress could do, and then there was a list in Article 1, Section 9 of what Congress couldn't do. There was also that Article 1, Section 10, where it was limiting what the states could do, but the question the states had is what could they do? So Madison puts down 12 ideas. We know that 10 of those ideas were all added into the Constitution in 1791, and they became known as our Bill of Rights. But there were two other amendments or two other ideas, proposals that Madison came up with. One was the size of the House of Representatives sitting at 65 members, and the other one was the congressional pay raises, which we talked about is actually added in the Constitution, but not until 1992, 201 years after Madison actually comes up with that idea. So as we stated, the first 10 amendments actually become the Bill of Rights. Okay, so we're going to go through those here, and we're going to a couple videos that are going to go with this. So the First Amendment is specifically talking about what are the individual freedoms we have. And so the first one is dealing with the freedom of religion. More specifically, the establishment of a religion and the free exercise of that religion. Very vague, lots to be determined later by the Supreme Court in terms of what exactly did Madison mean when he said we have the freedom to establish our religion, or on the other side, the government is not free to establish a religion. And then secondly, how we are able to exercise our faith. And the idea that if we don't want a religion, we're not required to also follow any specific religion. The second freedom that we find in here is the freedom of speech, that even being more vague than the one above it. And what the court has come to decide over the last 200 plus years is that speech can take place in really three different forms. One is what we call pure speech. That's what I'm doing right now as I'm presenting information to you directly through the use of words. One is what we call speech plus. A perfect example of speech plus is when we use our words plus an action. Picketing is a perfect example. If I'm in a car, I'm driving, and I see picketers, but I can't hear them, my windows are closed, the radio's on, I still can get the idea of what they're saying through their actions. And then the other one that we may understand, symbolic, or what we also refer to as expressive conduct, is another form of speech that the Supreme Court has looked at and said is also protected by the First Amendment, but Madison didn't specifically label that. Third protection here is the freedom of the press. of all the freedoms that are in the First Amendment, that one is the most open and most wide freedom. Um, we see it. We see it with the press today, how they can follow information, they can present information, even if it is at the objection of the government. Another one that is in there is the ability to peaceably assemble, and I should have put peaceable in there. To peaceably assemble, meaning we can get together in groups. It's interesting in the state that we're in right now that we're being told not to for safety reasons, but that's not what Madison was thinking about when he wrote this. And the last freedom is the freedom of petition, the ability, I spelled that one wrong, and I did it again. ION, the ability to petition our government. To live in a government where we couldn't challenge what they're thinking, we couldn't actually propose ideas to the government. This is a big one. This is a very important one, in that we do have a voice. We not only through the freedom of speech, but we also have the ability to tell our government, we don't like what you're doing, we don't like a particular individual, we want to recommend something new. That's what this one is referencing. So when it comes to the amendments quiz that you're going to take, once you get through all of this information, there's actually going to be 5 of them in that 40-point quiz that are going to be just the 5 freedoms of the First Amendment. So those are 5 easy points. The Second Amendment is one that many of you have heard about. It's the right to bear arms amendment. Now, if I break this down, the Second Amendment says that a well-regulated militia, a militia being a citizen army, not necessarily one that's dedicated or created by the state. So a militia being necessary for the security, this is the big point, security of a free state. Remember, the states were concerned about this. They came out of a system of the Articles of Confederation where they had their freedom. They were essentially 13 little countries, and all of a sudden now we're coming into this new government, and the states are being told that they're not individually free, that there is a national government. So they really want to see this documented. So a militia being necessary for the security of a free state, and the right to keep and bear arms shall not be infringed as the points of this particular amendment. That's a pretty big deal. They definitely wanted the ability to overthrow the federal government if they felt that it was infringing on state rights or not being protective of individual rights. So that Second Amendment, even though it says to keep and bear arms, should be taken in its full context as the necessary to keep a state free. Third Amendment is one that we probably will never see put into place again, but this was a big issue at the time of the Constitution, was the quartering of soldiers, actually having to house, feed, provide assistance to soldiers. And we can go back to looking at the American Revolution. We can look at even the Civil War, where people were told they had to allow soldiers to stay in their home. This amendment protects us from having to do so during peacetime unless Congress would establish a law that would require us to do so. All right, Amendment 4 is dealing with search and seizures. And we want to make sure we understand that we're still talking only about the federal government. This is really important to understand, that it is not until later that these pieces of the Constitution or the Bill of Rights actually start to apply to the state. So for quite a while, it is only applying directly to the individual, applying to the federal government against the individuals. And so when we look at the Fourth Amendment, there's 4 parts. These 4 parts will be on the quiz as well. The first one is that the people are secure in their person. I see that mistake. Place and effects, basically meaning that they are protected. I am protected as an individual, my home is protected, and my possessions are protected from the government coming in and just searching through my material. Now that'll take a little bit of a different turn when we start to look at, is that without any limitations? That's not the case. But so people are secure in their persons, places, and effects. Authorities would need a warrant to search and seize property, or to seize, take into custody me. They will need a warrant, but that warrant has to come from a judge. The warrant is from a judge, and it has to be, the judge will not sign the warrant giving authorities the ability to search unless the judge believes there is legitimate probable cause. And probable cause, as I've defined with criminology, is the likelihood that a crime has taken place, is taking place, or will take place. And so judges are not going to sign off on a warrant unless they believe authorities have a legitimate reason to believe something illegal is taking place. And finally, and with that probable cause, there is also the requirement of an oath, that any law enforcement who is requesting a warrant has to swear under oath that the information they're providing the judge is legitimate information. And then this fourth point is that the warrant will specifically identify, and this is going to give me some trouble here, the warrant will specify who, what, and where is to be searched. And so that is actually very important in understanding that they just can't go in and just say, okay, we got a warrant, we can search for anything. So if they're searching for a specific item, it's going to say that's what they're specifying. And again, I always refer to the Fourth Amendment as the what if amendment, because there's so many different things that might play in. There are certainly situations in which warrants are not necessary, but this is the protection that we have from our federal government just coming in at any point and searching through our possessions. All right, the Fifth Amendment. I always remind students this is pre-trial in activities. These are not necessarily, this is not the trial. This is not having counsel. This is not having witnesses. That all happens at the trial, and that's a whole different step. But the first major protection in the Fifth Amendment is what we refer to as federal due process. Now, due process is the, how do I want to put this? Due process is basically saying there's fair and equal treatment, and we're going to go right into the cartoon, fair and equal treatment under the law. And I wish it wouldn't have that, but we'll survive. So fair and equal treatment under the law. And there are two types of due process that it's important for you to understand, what is called substantive and procedural due process. Now, interesting, if we look at the substantive due process, we're looking at something that looks like the word substance. So what is the substance of the law is what is written in the law. And so the Constitution actually says what is written, the substance of the law, has to be fair and equal under the law. And then not just to say that the wording has to be fair, but how the law is carried out has to also be fair and equal. And that is key. Now, I say federal due process because there is actually an amendment that we're going to go through later that does talk about the state due process, and where states now, by the Constitution, are required to do the same thing as the federal government is in Amendment 5. So looking at that one, I'm going to move that one up just a little bit so I have room here. The second part of the Fifth Amendment that I want you to know is the double jeopardy clause. Being twice put in terms of life or limb, you can't be tried for the same crime twice. And so it's important for us to understand that if a verdict is reached in a criminal trial and new information comes out after the verdict has been reached, the government can't come back and say, oh, we got new information, we're going to try you again. That's double jeopardy. Back in the early 90s, there was a movie that I want to share with you that was actually called Double Jeopardy, and I'm going to try to get this so you can see this video, and I am going to try to get rid of my screen here so that's just the video, and I'm going to let you just watch this clip very quickly. One thing about that movie is it's not factually correct. Um, for that to be a factually and constitutionally correct film, there would have to be the crime would have to take place exactly as it did, including time, place, location, and that can't be recreated. So, is she compensated in a legitimate case? Would she be compensated for the time that she spent in prison? No, because a jury fairly convicted her based on the evidence that was available to them at the time. All right, so the next part of this is the protection of self-incrimination. Okay, self-incrimination is that you can't be required to convict yourself or to give information that would make you guilty. So when we hear people say, I plead the Fifth, that's what they're saying is I plead for my protection against self-incrimination. Okay, so that's the fifth one. The fourth or excuse me, that's the Fifth Amendment, self-incrimination. The fourth part of the rights of the accused is the need for a grand jury. In a grand jury in Minnesota is 23 jurors, and the purpose behind a grand jury is to determine and answer the question, is there enough evidence to charge someone with a particular crime? This is not the trial. This is simply a place for the prosecution to present to 23 people information that they have regarding a possible crime, and those 23 members are required to then decide, does the prosecution have enough evidence to actually charge someone and take someone to trial? Now I'm going to try and pull up a clip from Law and Order to let you see what a grand jury looks like.
I was assigned and was she qualified at first, but
All right, so what you're seeing here is these are the jurors, and you're only seeing a prosecutor in a grand jury. You're not going to see a judge. You're not going to see the defense. And what the prosecutor is trying to do is determine, is there enough evidence on his side to actually charge this person with the crime that they're trying to charge them with. So I'll let you watch a little bit more just to get an idea. And again, they're not determining, is she guilty? They're determining, does the state have enough evidence to actually charge her? The other thing you're not going to see in a grand jury is objections, because there is nothing to object to because there's no other side. And this is a grand jury is a major protection that most of us don't even know we have, in that the government cannot just charge us for something completely ridiculous unless they actually have the evidence to do so. So this is a great example. They don't have the full 23 members, but eventually what this group will have to decide is, does the prosecution have enough evidence to actually charge anyone with that crime? So we'll just kind of move out of that one. So that's another part of the Fifth Amendment. The final part of the Fifth Amendment that I want to cover is this fifth part. And it's something that a lot of people don't really understand, and it's a protection of us as individuals, but Some won't see it necessarily as a protection, and this is called eminent, and I know I spelled it wrong, domain, eminent domain. And basically, no, not that. Now take that out. Eminent domain is the government's ability to take private property for government purposes. And I always say that the best example that is close to us in eminent domain is North High School. North High School was built on several blocks of personal private homes. And when it was decided that they were going to rebuild North High School, and there was the major issue, where is it going to go? Many people wanted it to go where the existing or the old North High School was located. The old building, part of the old building is still there. That's our district center. But they had to make a decision that if they were going to build it on new land or not, where would it be? And they finally decided that they wanted the new building to be close to the old site. And so the government, through eminent domain, made the decision that they wanted to buy up the homes, and they gave the owners of those homes what they call fair market value. And in doing so, they bought up blocks of homes, leveled them, and built the school there. So that school actually sits on property where homes used to stand. The other thing we see with eminent domain, and that's what I want to touch base with you here on, is the wall at the southern border. So with that, I am going to end this video on the first 5 amendments. So if we go through this and try to figure out what are parts for the test. So of a 40-point quiz on the amendments, freedom of speech, religion, press, petition, and assembly, there's 5. The militia, the quartering of soldiers, there's 4 in the 4th Amendment, and there's 5 in the 5th Amendment. So you've got a lot of points just literally teetering on those first 5 amendments. I will create another video for Amendments 6 through 10, and then I will get into the rest of them as well. Hope this all came through clear.